Hi, I'm George Whipple. Welcome to Employment Law This Week. As 2024 comes to a close, we're taking a look back at the stories that shaped the year in employment law. Epstein Becker Green held its annual workforce management briefing in October right here in New York City. We took the opportunity to ask attorneys from across the firm what had the most impact on their practices. We began with the Supreme Court's landmark Loper-Bright decision. After 40 years where federal agencies enjoyed Chevron deference, this ruling returned questions of statutory interpretation to the courts.
It's going to have a huge impact potentially on the way that the National Labor Relations Act is interpreted and whether the board's decisions are entitled to deference, which is really important given how frequently the board changes its interpretation of the act.
We think that Loper-Bright's going to have a huge impact on how far the DOL can go in its rulemaking efforts.
It's going to be very important to see how the courts apply Loper-Bright.
The ruling overturning Chevron dominated the headlines, but much of its effect is still to be seen. For some clients, the biggest challenge wasn't court rulings, but employee trends.
The biggest impact for my clients has been the increase in union organizing activity, the rise in popularities of unions generally, the increase in strike activity, and the economic demands we've seen at bargaining. The pendulum right now at the bargaining table has swung very much on the labor side.
Employees have been a lot more open about discussing mental health conditions in the workplace, which is great from an inclusion standpoint, but it can be very difficult for employers to navigate, particularly as employees are disclosing mental health conditions during all phases of the employment life cycle, like employee separation or when discussing performance.
The rise of AI captured everyone's attention this year, and EBG clients were no exception. Workplace artificial intelligence tools are rapidly evolving.
For the last several years, leading the pack was tools that employers use for recruitment or selection, where the AI would identify if the candidate was a good fit and how good of a fit that person was. Employers have started to move past that, particularly with vendors becoming more creative with their AI tools and are helping employers not only identify good fits for hiring, but good fits for given jobs, for career planning, and of course for performance evaluation purposes.
We also asked which new state and federal regulations created the most notable shifts for our clients.
The increase in equal pay laws and pay transparency laws, employees are feeling emboldened given those laws. They're raising concerns to the employers, and employers are needing to tackle those through pay equity audits.
The introduction of the Pregnant Workers Fairness Act has been a big change for our clients across the past year, and our clients are really having to implement the new requirements to build it into their reasonable accommodation process and to have to figure out new ways that they are working to accommodate pregnant workers, those who have just given birth, or, in some instances, even those who are trying to get pregnant.
In April 2024, one federal agency moved to change things drastically for employers. This action and the response was top of mind for many clients this year.
The Federal Trade Commission's decision to issue a rule banning post-employment non-competes across the country. Many employers use non-compete agreements to protect their business interests, like trade secrets and customer relationships. So this rule had a very significant impact on how employers do business.
The FTC's non-compete ban was one of the first federal agency actions blocked after the Loper-Bright decision. It never took effect, and it appears that it is likely dead, especially under the incoming Trump administration. There is some hope that the end of Chevron will stop the whipsawing back and forth we've seen in agency actions over the past few administrations. But the workplace is changing rapidly, and as we've seen today, there are a wide range of issues impacting clients. To round out the year, we asked employment law co-chair David Garland how Epstein Becker Green is adapting to meet the moment.
It's been another year of growth for our practice, our labor and employment practice. First, we continue to enhance our capabilities on the West Coast. We've added talented lawyers in our newest office on the West Coast, which is in Portland, Oregon, to service clients in the Pacific Northwest. So it's important that we've continued to strengthen our bench and the capabilities that we can deliver to our clients on the West Coast. And the second area, which is just as important, is that we've continued to expand the capabilities, the strength, the depth, the expertise in our benefits practice. We've opened an office in Pittsburgh where a very talented group of benefits lawyers have joined us in the last year, almost doubling the size of our employee benefits practice and being in a position to deliver the most sophisticated advice and work in the benefits space to our clients.
That's it for this year. Thank you very much for watching, and we'll see you in 2025.